Hi, and welcome back to Chapter 10 in your commercial law curriculum. Up until now, we've been talking about the formation and the analysis of a contract under common law. In Chapter 9, we talked about once the contract is formed, performance and discharge of the obligations under the terms of the contract. Today, we're going to talk about what happens if performance doesn't happen. What happens if the obligations aren't discharged? What are the remedies available in contract law? After today, I want you to be able to identify the types of legal remedies available, list the different equitable remedies available to parties in a contract, differentiate between a legal and an equitable remedy, understand the concept of mitigation of damages, and understand the term election of remedies. So when we have a fully formed and legally enforceable contract, certain obligations arise with regards to the parties to the contract, and the parties are supposed to perform those obligations. When a party fails to perform its obligations under a contract, the injured party may request a court award compensation for their losses. This compensation is known as a remedy. The type of remedy a court can grant will depend on the kind of injury suffered. But remedies fall into two general categories, which we'll talk about today: legal and equitable remedies. A legal remedy is a monetary damage that the party can claim for the loss suffered as a result of the other party's failure to perform those contractual obligations. These are the types of remedies most commonly sought and awarded in contracts lawsuits. They're usually known as damages. The other type of remedy a court can order is non-monetary, and it's known as equitable relief or an equitable remedy. This is awarded when there's no suitable monetary remedy available, and the court can fashion this kind of remedy according to the facts of a case. Courts often determine appropriate damage to award an injured party by evaluating the extent and the severity of the non-performing party's acts. When damages have been suffered by an injured party, the court is going to attempt to place that party back in the same financial position it would have been had the non-performing party actually performed their end of the bargain. Consequently, money damages are usually awarded when someone has breached a contractual obligation and that breach resulted in damages. The legal remedies that are awarded by a court can be categorized as compensatory, consequential, nominal, and liquidated. Another type of damage that you may have heard of is punitive damages. This is a type of damage that is rarely awarded in contract cases because it's usually associated with typical tort claims. But let's talk about each one of these in turn. The first and most common type of damages we see in contract cases are called compensatory damages. And these are the actual sums of money a party has lost as a result of non-performance by the other party to the contract. They're also known as actual or expectation damages. And what the court is trying to do here is put the injured party in the same position it would have been had the contract been performed. So therefore, it's not just the actual money loss, but it's also anything that is foreseeable and probable as a result of the breach of a contract. So the natural and proximate consequences of the acts of the non-performing party should be reasonably foreseen and predictable. So that means that if a party to a contract expected profits based on the performance of the contractual obligations, the injured party may be able to sue for lost profits or things like incidental expenses or the actual amount they lost under the contract itself. In addition to compensatory damages, plaintiffs can also be awarded consequential damages, and these are indirect or special damages that are foreseeable as a consequence of a breach of an obligation under a contract. These are usually awarded, again, in addition to compensatory damages. They can't be speculative. In other words, they have to be, the parties have to have reasonably known that these type of damages would result from a breach of contract. And the central question is, did the parties know or should they have known that a breach would result in the damages claimed? There's a famous case, Hadley v. Baxendale, that's in your book. It's a good one to take a look at, and it really differentiates this point between known, should have known, and didn't know. Next, I want to talk to you about nominal damages. Nominal means not much, really. Um, and this is a situation where you do have a breach of contract and there is a damage, but it's a very small damage. So this is a situation where the court will acknowledge wrongful contact. I'm sorry. This is a situation where the court will acknowledge wrongful conduct on behalf of the breaching party, but the compensation that the plaintiff is entitled to is small or minimal. Let's talk about liquidated damages. These are the kind of damage that we like to include in a contract. In business, we like certainty. We abhor uncertainty. And so we want to know up front that if one party or the other doesn't perform, what are the consequences? And that's where liquidated damages come in. It's where the parties that agree in advance that a certain sum will be awarded in the event of a breach. In order for these to be enforceable, they have to be reasonable, fairly anticipate the cost of the breach. They can't be punitive in nature. In other words, you can't charge, if the actual damages would be $5, you can't say liquidated damages are going to be $10,000. That would be punitive in nature. And speaking of punitive damages, they're usually not awarded in contract cases. That's something that we see in the civil litigation realm, not in the contract litigation realm. They're only awarded in extreme situations where the breaching party's conduct is so egregious and intentional that they create this complete disregard for the rights of the injured party. And the court really wants to teach the breaching party a lesson that they never do something like this again. One situation where you may see punitive damages is in a state statute for something called treble damages. Treble means triple. And treble damage statutes basically take the actual damages and triple them because conduct may be so egregious in some situations. In some instances, the non-breaching party, the plaintiff in a case, may have a responsibility to mitigate the damages if they can. We most commonly see this in lease, in real estate situations. If you lease an apartment from someone and you sign a 12-month lease, and 2 months into that lease, you move out, you break the lease, you violated the terms of the lease. Well, the landlord in that case can't just let it sit idle for the entire rest of the lease. They have a duty to mitigate the damages or try to release that apartment. They only have to use reasonable efforts, maybe advertising it in the paper, maybe posting it around, but only reasonable efforts to try to mitigate the damages. They don't have to go to extraordinary lengths, but they do have this duty of mitigation. Okay, on to equitable remedies. Sometimes we said monetary remedies are insufficient to compensate a party for injury sustained. And in this case, a party can request an equitable remedy or a non-monetary remedy. The equitable remedies available in contract law are specific performance, injunctive relief, rescission, reformation, restitution, and reliance. When an equitable remedy is appropriate for the injured party, the court will base it on the facts of each case and try to fashion a remedy that, again, puts the plaintiff back in the best possible situation. The first equitable remedy we'll talk about is specific performance, and this is an equitable remedy that is unique to contract law, and it is used to enforce the obligations under the contract. In other words, the court will look at the breaching party and say, no, you're going to have to go through with your obligations under the contract. It's purely within the discretion of the court, and it's usually only used when there's some unique subject matter of the contract. Usually we see this again in real estate because the nature of real property is something that can't be substituted. You can't have substitute performance for real property. If you want to buy house A, you can't substitute house B and say, you're okay, I've made you whole again. And so in the case of real estate, if we have a contract for the purchase of real estate and the seller backs out, the court may order specific performance In other words, order the seller to go through with the sale of the real estate. The next type of equitable remedy we'll talk about is one that we see in all aspects of civil litigation. It's not specific to contract law like specific performances. And that's injunctive relief. And it's granted when one party can show that monetary damages are going to be insufficient compensation and that immediate and irreparable harm will occur if some type of injunctive relief is not granted. And so what we're doing with injunctive relief is telling one person or the other to stop doing something or continue to do something and not breach the contract. It normally progresses in 3 stages. There's a temporary restraining order, lasts a short time, 10 days to 2 weeks, that gives the party some time to get to the hearing, a preliminary injunction which will be effective until the full trial, and then possibly a permanent injunction which will last until performance has been completed. Let's talk about reformation and rescission. Reformation is when the court reforms, that's the term reformation. The court reforms or rewrites a contract. It may be a clause in a contract, it may be the entire contract, as an equitable remedy to reflect the true intention of the parties. It usually happens in the cases of mistakes. Rescission, on the other hand, is when the contract is set aside, and there's 2 types, either voluntary or involuntary. Voluntary is when the parties get together and they agree to set aside all of the obligations in the contract, and all the obligations are therefore discharged. Unilateral rescission, on the other hand, is when only one of the parties decides they want out of the contract, and in this case, the non-breaching party can go to the court and ask for a rescission of the contract, put me back in the position I was before the contract started. With equity, we're attempting to avoid injustices that may occur in the legal process. Injustices are sometimes remedied by what we call restitution or reliance damages. Restitution damages prevent another party from being unjustly enriched because of the breach of the breaching party's acts. Restitution focuses on the value of the benefit received by a party that was unjustly obtained. It can be awarded in a breach of contract claim or in a quasi-contract claim. Reliance damages come into play when we have promissory estoppel, which we've talked about in the past. And this is where one party has changed its position in reliance that the other party would perform their obligations under the contract. And a court can award damages for the amount expended in reliance upon performance. And finally, we've got a lot of different options here as far as remedies go, and the non-breaching party usually has to elect a remedy. When 2 or more available remedies for a breach of contract exist but are inconsistent, the non-breaching party may be required to make an election of remedy. So, to summarize what we've talked about today, there are 2 general types of remedies, legal and equitable. Legal is a monetary remedy, whereas equitable is non-monetary. If money damages will suffice, equitable damages are usually not available. The type of injury will dictate the type of remedy. With regards to legal remedies, we have compensatory, consequential, punitive, nominal, or liquidated damages. Equitable remedies include specific performance, injunctive relief, rescission, reformation, restitution, and reliance. Remember that parties are required to elect a remedy when more than one remedy is available, but they are mutually exclusive. Compensatory and restitution damages, for instance, are mutually exclusive, and therefore one must be chosen over the other. Well, that's all we have for this week. I hope you have a great day. As always, if you have any questions, don't hesitate to contact me, and we'll see you back here next time.